Good morning to you all, my fellow Muffin clan. Today is a bit different from the regular gaming videos that I normally do. Today, my group and I will play a major role in the super duper Law of Torts assignment that is coming to you soon. So stay tuned to that. So this video will be about discussing how relevant the Bolam Test is in determining the standard of care in medical negligence cases in the UK and Malaysia. Firstly, we need to understand the definition of negligence. What is negligence? Negligence is the failure to take responsible care to avoid causing injury or loss to another person. An example of this can be seen in manufacturing firms where the manager's failure to take reasonable care to maintain the pristine condition of the equipments used in manufacturing, causing their subordinates or their employees or their clients to get hurt or maimed in the process if an accident actually does occur. There are three elements identified in proving that there is a negligence claim by the plaintiff. Firstly, the plaintiff must prove that the defendant had owed a duty of care towards the plaintiff based on the circumstances that had occurred in an incident. The second element is how the defendant had breached their duty by failing to act in a reasonable way that may have been able to prevent the incident in the first place. The third and final element is the damages that the plaintiff had suffered in the incident, such as how injured they were due to the defendant's action. Now you guys might be wondering, Hillman, what is the exact standard of care that people should take under law to ensure the safety of another person? Well, my friends, standard of care has been measured by law as a balance between failures that are particularly bad and where a genuine accident had occurred. Defendants are held to the standard of the reasonable man as seen in Donahue and Stevenson.
The Bolam Test was introduced in the case of Bolam v. Friern Hospital Management Committee. It is a standard test that is used to see whether there was any breach of duty of care during any medical performance taken place by any medical practitioners. If a doctor, nurse, dentist, radiograph or any other medical related staff fails to take a certain amount of standard care on towards a patient, it can lead to medical negligence compensation claim. Common examples of medical malpractice are when a doctor, hospital or other related medical practitioners causes any injury to the patient due to negligent act or omission such as diagnostics error, treatment error, aftercare error or errors in the health management. Therefore, medical professionals have a duty of care to keep patients safe from harm. The Bolam Test establishes what should have been the correct standards when assessing medical negligence. The test basically shows the medical practices must have had compliance or accordance with a responsible body of opinions. Therefore, medical professionals should show that they took procedures that a body of medical professionals in the same area would have accepted or take into account if it was fair. So the Bolam Test decides whether a medical act is right or wrong according to the opinions of several medical staff in the same area, whereby this will prove if a doctor or medical profession was negligent or not. In 1957, Mr. John Bolam was diagnosed with relapse depression and was admitted as a patient in a mental health hospital when undergoing electroconvulsive therapy. Mr. Bolam was not given any muscle relaxation nor was he restrained. Consequently, Mr. Bolam fractured his hip and suffered multiple injuries. This led Mr. Bolam to claim damages to his injuries due to the fact that the doctor negligently performed the procedure and failed to inform him of the risks involved. Eventually, Mr. Bolam had failed to attain compensation when Friern Hospital Management Committee. The court held that the medical team had not done anything wrong and had acted in accordance in the procedure accepted as a proper by a reasonable body of medical professionals. The standard of practice at the time was that it was not acceptable to use muscle relaxants, neither would doctors restrain patients. It was also said that the standard of practice was not to inform patients about the possible injuries from electroconvulsive therapy unless when asked. So there was no negligence found. Thank you.
Broadcasting live from Taylor's University, good afternoon everyone. Today we'll be reporting on a parliamentary hearing about a highly discussed topic, which is the relevance of Bolam Test in the UK and Malaysia today.
We have debated whether Bolam Test is still relevant today, especially in proving clinical negligence. So, When judges make judgments, they will apply this test to ensure that the judgment they give is supported by professional and reliable opinions from people who specialize in this field. So before we start, I'm just going to tell you why Bolam Test is still relevant and how it advantages all of us. So first of all, the test protects hospitals and doctors from floodgates of claims. If they were all liable for all the claims made, eventually they will start protecting themselves as to not be sued, then the good of all the patients, which generally harms all of us here. Secondly, it is relatively difficult for judges to interfere with an unfamiliar field. This way, they might give out an unfair judgment. It is relevant to apply the test to cases relating treatment and clinical judgments. In White House against Jordan, the House of Lords ruled that the defendant did not act negligently, as the evidence did not establish the fact that the doctor departed from the accepted practice. In this same 1981 case, Lord Deney also reaffirmed the relevance of Bolam Test in measuring standard of professional activity. Also, this test covers the examination and diagnosis section, as shown in a 1985 case, Maynard against West Midlands Regional Health Authority. Here, defendant was not negligent, as even though he operated before obtaining the results of the test he ran. According to professional opinions, they said they would have done the same because the disease was fatal if not operated early. Also, doctor's standard of care does not depend on his or her level of expertise. A junior doctor and a senior doctor are expected to have the same standard of care. This is illustrated in Wiltshire against Essex Area Health Authority, a 1988 case. So, now I just want to say that the test is still applicable today. In a 2019 case, Flanagan against University Hospital Surgical Plymouth NHS Trust, here held that the defendant was not liable for multiple allegations of breaches of duty regarding the surgical procedures undertaken. In this case, 4 neurosurgeons were called in to discuss about this issue, whether the defendant was negligent in choosing to perform an ACDF instead of a vertebrectomy. So far, we've only been looking at UK cases. Let's take a look at the position of Bolam Test in our very own country, Malaysia. In 1967, the test is applied to assess a doctor's level of competency. In case Chin Kiao against Government of Malaysia and another, Privy Council found the doctor responsible as it was already expressly written in the patient's medical card that she was allergic to penicillin, but yet she was given a penicillin injection. In 1982, the same test applied to Khao Nan Singh against Nagama and another. Here, the court held that the defendant was liable as he did not act according to the complaints immediately, causing the leg later on to then be amputated. It is an understood fact, especially for doctors, to know that plaster of Paris that's applied too tightly might cut off the blood circulation, eventually causing formation of gangrene. Whereas in 1997, the test also applied in case Shalaya Anadalati Medicum and another against Kerajaan Malaysia. Here, the test is applied to show whether the doctor was negligent in making diagnosis and if the doctor's actions were backed up by professional opinions. Now, I would like to say that the test is still relevant in making judgments, although there has been divergence from the very original test first introduced in 1957. This can be illustrated in case Pupuma against Lim Suhao and another. Here, the court emphasized that the standard of care in medical negligence is restricted only to the duty to advise the risk associated with any proposed treatment. With regards to any diagnosis and treatment, the test still applies, but the judges get to make the final call as established in Bonito. This is also supported by a Malaysian case, Lu Sonyong against Vista Laser Eye Center Sendirian Berhad. Here, the professional opinion was dismissed as it has very little probative value. So to sum it all up, I would say yes, the test is still relevant till this day. There has been slight departures and changes from the very first original test, but all this just shows the intention of parliaments and courts to to still apply the test in cases regarding medical negligence. And that's all I have for today. Thank you.
One of the main drawbacks of the Bolam test is that the test protects medical practitioners to a certain extent. It has already been established that in the Bolam test, the medical procedure carried out by the defendant need only be certified suitable by a reasonable body of medical opinion, which refers to a reasonable group of medical professionals who are all skilled in that particular area. The test became merely a requirement for the defendant to look for other experts who would declare that they would have done what the defendant did. The judges had no say regarding the reasonableness of the medical professionals. It can be argued that judges are not qualified to make professional judgments on practices of other learned professions such as medicine. This led to a slight alteration to the Bolam test through Bolito against City and Hackney Health Authority, where if the medical opinion is not logically supported, judges would have to decide if it was reasonable or not. An example of a case would be Loveday against Renton, where it was mentioned that the judges would have to evaluate the soundness of the witness's opinion, including whether there was biasness. This case was later cited in the Malaysian case of Datuk Dr. V. Turai Singham and another, against Sanmarka Anak Lelaki Ganapati and another. The modification of the Bolam test further proves that there are some flaws in the original test which might give rise to injustice. Okay, that's the first paragraph. Yes, stop reading. Informing patients of any risk is illustrated in the Australian case of Rogers against Whittaker. This landmark case resulted in a departure in Bolam. The High Court held that patients should be informed of any material risk that is related to the treatment. The court also stated that informing the patient the truth or answering the patient truthfully overrides any opinion or practice held by a respectable body of medical men, as required in the Bolam test. This clearly suggests that the Bolam test should be put into a subsidiary role instead of the main determinant of standard of care. The test need only be one of the factors considered when deciding the standard of care of a medical professional. This statement was clearly affirmed by Lord McNair himself in Bolam against Friern Hospital Management Committee, where he himself did not intend the doctor's expert evidence to be conclusive of the question of breach. In Sidaway against Board of Governors of the Bethlehem, the courts applied the Bolam test, but in fact, informed consent was acknowledged as an important element as well. Malaysian courts also applied the position in Rogers against Whittaker, as stated by the Federal Court in Zulhashima binti Hassan Basri against Dr. Kupu Velumani. In Lu Sonyong against Vista Laser Eye Centre Sendirian Berhad and another, informed consent was looked into as well. The patient was adequately informed about the procedure and risk before his eye surgery, and there was no breach of duty against the defendant in that sense. In regards to medical law, individuals should have the freedom to mediate on matters concerned to their well-being. It is therefore submitted that the Bolam test may continue to apply for diagnosis and treatment, but there should exist a duty for doctors to inform their patients of any possible risks.
The third question, which challenges the Bolam, is when will the court state that a deviation from the standard professional practice is to be regarded as negligence. Much difference is given to the medical opinion, even if such opinion deviates from the norm. For example, in the case of De Freitas against O'Brien and Connolly, 1995, despite only 11 surgeons out of 1,000 surgeons claiming that they would have carried out a certain procedure, the court still accepted the small percentage of reasonable bodies of opinion, stating that it is still reasonable. This specific case showcased one of the few limitations of the Bolam's test. The court decided that the negligence of the defendant is solely based on the opinions and practice of a professional body of medical men. However, it is questionable that the opinion of 11 surgeons, as opposed to the 989 surgeons with similar experience and qualifications, are taken for the fact that they are still a small body of opinion. This indicates that if a doctor is being sued as being negligent, as long as he finds a small group of medical men which supports his practice, the court will be unable to help him liable for his actions. From this, it shows that the irrelevance of the test in proving one's negligence, as even a minority stand could be free one from its fault. In the Malaysian's perspective, the case of Kamalam Anak Perempuan Rahman and others against the Eastern Plantation Agency in Johor followed the case of Roger and Whittaker. Per Justice Richard Halala, the ultimate question, however, is not whether the defendant accords with the practice of his profession or some parts of it, but whether it conforms to the standard of reasonable care demanded by the law. This is a question for the court, and the duty of deciding it cannot be delegated to any profession or group in the community. We can see that even the practice was supported by a responsible body of specialists. It is up to the court to decide what is the final decision. A deviation from the standard professional practice might not be regarded as negligent. In many jurisdictions, the Bolam Test has either been radically modified or rejected altogether, such as the case of Roger and Whittaker. In Roger and Whittaker, the defendant failed to inform the claimant about the risk of her left eye contracting sympathetic ophthalmia. She then brought this case to the court. The body of medical opinion is that she did not specifically ask if the procedure would affect her right eye. However, the court held that providing patient the truth overrides the opinion provided by the specialist. All the possible risks should be informed to the patient, and it should be factually correct. There exists a body that provides their opinion, but their opinions on this matter is very much questionable. Do these medical men deserve to play this role, as for a fact that their opinions cannot be rectified by the others? We do not know if their school of thought is reasonable, thus their validity is unable to be defined. In the case of Fufiana against Dr. Su Fon Man and another, the Bolam test was rejected and the Roger and Whittaker test is being used. Bolam test has no relevance to duty and standard of care of a medical practitioner to provide medical advice regarding risk of proposed treatments. One is held liable if he, as a medical practitioner, fails to inform the patient about the material risk involved. This is known by some as the Roger and Whittaker test. In this case, she was not given information about the risk of paralysis that might be caused due to the treatment process.
Order in the court. So now is the time for me to make the final judgment on this very long feud. The court holds that the Bolam test is still relevant in this day and age when looking into the recent cases that Jing Hui and Angelina have pointed out, as seen in Piu Piu Ma and Lim Su Hao and others, where the use of third-party experts in the field of medicine made it easier to hold judgment due to the judge's lack of knowledge in that particular field. However, in order to maintain the relevance of the Bolam test in the future, some of these changes must be needed in order for it to stay relevant. This would include the court themselves choosing a specific body of experts in various fields with no affiliation to either party so as to prevent any possible biasness that could occur, ensuring that the case would have a neutral judgment and both parties, plaintiff and defendant, standing an equal chance in the case battle. So that should be all, both of you. Now I hereby declare this case adjourned. Next case, please.